Hey, John, good to see you. Thanks for being here.
Always a pleasure, Gene. Good to see you. Hang out, talk about patents.
Yeah, so I really appreciate you being on the podcast here this week, and I've been waiting to have you on the podcast. We've been doing it now for a little bit, but wanted to try and pick a time when it might be a bit more topical and interesting. And you've written something for us recently, and I know you're talking about writing some more stuff about what's going on in the patent system, and to try and maybe calm people's nerves and fears. And it's an uncertain time, and not that that's a bad thing, but at these types of moments, we're doing this right before President Trump is going to take office again. And we think we know what might happen. We're not sure we know what's going to happen. Patent policy is driven by people, so whoever he ultimately picks is going to matter a lot. So there's uncertainty in the air, and I thought that now would be a great time to get your perspective, because you've been doing this. It's hard to believe, but I know how long I've been doing it, and you've been doing it a bit longer. So you've been doing this for 40 years, right?
40 years. I was working as an engineer at Fairfax County and going to night law school at GW, and I got to know that some of my classmates worked at this place called the Patent Office. I didn't know what a patent was, but they paid for at least half of law school. And being at GW, that was an invitation I could not turn down.
Right. Yeah, I always tell people, if you can figure out a way to get a law degree for nothing or very little, then it makes a lot of sense.
It does, and I was bitten very hard by the patent bug. I was fortunate. I was hired by a guy, Don Kelly, and if you're out there, Don, hi. And he, shortly after I arrived, became the executive assistant to then commissioner, and that was the top banana at the patent office at the time, Don Quigg. And so I was taken along as a speechwriter. And so I got to see the patent office first as an examiner, from the bowels of examination and search rooms and paper and all the terribly interesting characters that inhabited the patent office. And then I also got to see, I think it was the 9th floor then, was the top floor.
Over in Crystal City, right?
In Crystal City in CP3. And I got to hang out with all the inductees to the Inventors Hall of Fame. I got to write the intros for all of them. For the commissioner at the time. It was a fantastic experience, and boy, did I become an admirer of the patent system. What it meant in American lore, what it meant then, what it meant for the future, and I've kind of watched it like a laboratory animal ever since.
Yeah. Well, and we've been teaching the patent bar review course together now I've been doing it over 25 years. I know you've been doing it longer, and I always give you a hard time when you're talking to the students and you tell them, okay, just sit back for a minute. Let me give you some historical perspective. And you like to start with like ancient Mesopotamia. Not quite.
I'm just this side of the Fertile Crescent with respect to the patent system, right?
Right, but you do. You have a deep historic understanding of the patent system, and you don't maybe start with ancient Mesopotamia. You maybe start with the Bible, because you, as an examiner, hopefully you'll tell that story here in a minute, have used the Bible as a reference once. But but you have this, and we'll touch on these things, but you have this historical perspective in part because of your time writing speeches for then Commissioner Quigg, right?
Well, I do, and I had to research things, and there's a lot of interesting data points out there, and the patent system has sort of been on a sine wave of success and failure, and then rising from the ashes, and then failure, and so forth, ever since its inception. And I think the best example of that, to reveal just what can happen in the span of a single generation, is Edison would have over 2,000 patents. Or 2,500. But he became very disenchanted with the patent system and gave up filing applications for a decade. Yeah. And this is a person of historical lore in our system. Venerated, everybody talks about Edison. And even in his lifetime, he was a big filer, became disgusted, stopped, and then started again.
Yeah.
So, yeah, it happens.
So it is a sine wave. And I have had over the years some of the old timers. I'm becoming an old timer myself, but some of the folks that were around in the 70s, who are pretty advanced years now, have told me, don't fret. We had it. At times they said worse. Now they said just as bad. But there is a way out, and it is a sine wave pattern, it seems.
It is, and that is why my trajectory is, I think, particularly interesting, because I signed on at the Patent Office in a time when it was rising from the ashes. There was a lot wrong with the system in the 1970s. It was considered by many people, and in the beginning of the 80s, you had the creation of the CAFC to consolidate patent appeals into one court. It just happened to be located in Washington, but it took its start from the old CCPA. But at the same time, the commissioner just before the one I worked for, a guy named Mossinghoff, he was very politically adept, and he negotiated a deal where if the Patent Office could keep more of their money, they could hire more examiners and get rid of the backlog. And so when I was an examiner, the mantra was to knock down the backlog and knock down pendency, because a non-working patent office, it's justice delayed, justice denied. And so the longer the backlog, the less incentive and involvement there is by the people we are relying on to create our future. And so they wanted to knock down pendency to 18 months. Mm-hmm. And so the thing was 18 by 85. Well, they didn't make it. Then it became 18 by 87. No, they didn't make it. Then it became 18 by 89.
Yeah, by the end of the Reagan term. And they got really close.
They got
It was
there.
like, 18.1 or something like
they
that?
They celebrated it. And the funny thing is, my PEIT instructor, a guy named Gil Weidenfeld, was the MC for the celebration. And he joked with me, this is after I'd left the patent office, yeah, John, we will have achieved it for a solid 2 months.
Before it starts to grow
Before
again?
it starts to go the other
Well,
way.
but yeah. President Reagan, and not that he was necessarily the decision maker on these issues, but whoever he was listening to got resources. They gave the Patent Office resources to do this.
Well,
this is not a zero-sum game. There can be winners and there can be losers, and if you want a better patent system, it does require at least a commitment at the top to do what is needed.
Well, and a little continuity doesn't hurt. The CAFC idea came from within the Carter administration, but it was followed through on by the Reagan administration. And so no one can deny that the CAFC was a seminal moment in what happened in the patent office, or not the patent office, but the patent system for the next several decades. But right now we have a little bit of that same continuity. We have people on both sides of the aisle in the Senate and in the Congress who believe that these patent adjustments, these respective sets of legislation, ought to get passed in some form. I'm not going to say they're in final form now, but PIRA, Prevail, and Restore, there seems to be a real momentum, and it looks like that's going to carry over into the new Congress. So that's good, in my estimation. And we're at another place or point in time, it seems to me, where the system can rise from the ashes.
So historically, is it a situation where, I almost don't know how to ask this question. I mean, it's going to probably require a bit of a discussion, I suppose. But it seems to me that there are, members of Congress and other policymakers and regulators who are not involved in the patent office day to day, the patent administration, who don't get it isn't the right way to say it. It's that, they're off working on farm bills and agriculture. They're working on security, national defense, cyber threat, the military. They have their own focus. And it seems like at certain moments in time, then they all get sort of crystallized. They all come together and say their eyes are open. And I wonder whether we're going to have that moment now, because I'm starting to hear more and more from people that when these other policymakers, these other members of Congress and Senate are told that you can't really get an injunction in the U.S. They're incredulous. It's like, what do you mean?
Flabbergasted.
They're
Right,
flabbergasted is exactly the word. That's exactly the word that I've heard used. They're flabbergasted.
Well, yeah, just because everybody thinks that if nothing else, that a patent is something you can prevent others from imitating or copying. They're not exactly sure what infringement is or scope of a claim or anything, but by golly, they understand that the whole reason you got a patent was to stop others. But you mentioned something there that it's a moment that creates sort of the conditions for crystallization. And in the late 70s and early 80s, if you cast yourself back to then, we had the oil crisis, we had a lot of things. And Carter even made his famous malaise speech from the White House and encouraged us all to wear a sweater and turn down the thermostat. And I think there was a real concern that we were losing our edge and would lose our edge. And the Soviet Union was seemingly on an upward trend. Little did we know how hollow that was. But from the outside, it seemed like they were kind of on the march. They were themselves in Afghanistan back then. And so Reagan comes along and he's beaten the drum of patriotism. And there's nothing more patriotic than innovation, And so the resources were put in place. So Carter started it with the idea behind the CAFC. Reagan continued it by making that happen and then investing in the patent office to get the backlog down. And you began to see a real innovation renaissance, which I think peaked in our lifetimes anyway with the dot-com era. Mm-hmm. Because it kept on going through Clinton, and it was like anything was possible. Money was freely available. Innovation was all over the place. And some of the largest enterprises we have today, like Amazon, Google, and so forth, those seeds were sowed in that dot-com era. I mean, people can say, well, nothing useful was created. I beg to differ. Right. There was an awful lot that was usefully created. But then we kind of went into a doldrums again in the 2000s, an attack on the patent system, and you saw outlines of it with the BlackBerry decision and so forth. Oh, no, an injunction is too powerful a tool. And getting patents on the very things that make our economy work. All this dot-com stuff, too much, and the patent office is incompetent. And so we kind of went into another doldrums, and we're coming out of it, I hope, at the moment.
Mm-hmm. So why do you suppose, I mean, I have my own thoughts, and I'm happy to share them, but before I do, to get you to react, have you given any thought as to why that happened? Why did we get into that kind of patent malaise in the early 2000s?
Well, I think it came from a couple of things. The CAFC had sort of jacked up the patent system. You saw big judgments being affirmed at the CAFC. You had chief judges there who were, patent. They were big fans, and so. Things were churning along, and I think companies felt they were being picked on in some way. And this really began to take hold when you saw some of the decisions being made in the late 1990s and early 2000s. Really large checks were changing hands. And I think BlackBerry was the shakeout, that a patent group having a patent on a contingent basis could threaten an enterprise that all of DOD relied upon, which was the encrypted BlackBerry system.
Right.
And suddenly it was like, wait a minute, this can threaten national defense? And suddenly, wait, who are these people getting these patents? And it kind of became a free-for-all. And Google et al., Facebook, whomever, jumped on those coattails and rode it all the way to Alice.
Yeah.
Yeah.
And so I think that there's a couple of things there. Obviously, the BlackBerry thing was a seminal moment, right? That was one where all the business people, all the folks on Wall Street, all the people on Capitol Hill. What do you mean I'm not going to be able to use my BlackBerry at 12:01 a.m.?
Yeah, that does not compute.
That does not compute, and so I think that there was that moment, but I think if you peel back the layers of the onion or look behind the curtain, I think there's two things that really caused great problem. One is, who was it that was doing this to BlackBerry? And it was not an innovator. It was a group of attorneys who had bought a patent and then went after
Right.
BlackBerry. And I don't think it should matter who owns the patents, but I do think we've lost that fight. Definitively have lost that fight. And I think the patent industry holding on to, well, it shouldn't matter who owns this. Well, it does. It does.
It does, and you know, you and I follow the patent office, you know, like a lab animal, and some of the commissioners or directors over the years, and not to single out Michelle, but she expressed a sentiment that those patents that weren't being practiced were not, quote, legitimate.
Right.
And
it's Michelle Lee.
Yeah, Michelle Lee. And the problem there is that was certainly her feeling, you know, and I don't hold it against her for having expressed it and so forth, but that's not how the statutes and the system work. Because you have an awful lot of folks that are then creating illegitimate patents, and that would be all of our universities,
Right.
for example.
For example. So I agree, and I think that...
And again, I'm not picking on her, but she brought it to that level, which is right at the very top of our system in our government, is unless you're practicing an invention, whatever protection you have on it may well be considered illegitimate. Wow.
So for a strategic, and we're supposed to be, as lawyers, in the art of persuasion, right? We're in the business of persuading people to our side. I think it would, and I still think it continues to be a mistake to lump every patent owner together. But I think so as long as we are lumping everybody together, the person who just swoops in at bankruptcy, buys the patents, and then has got the war chest to then go after people. And I mean, as long as we lump that person together with a university, together with, like, for example, Qualcomm or Ericsson, there's a whole, or InterDigital, or any number of innovators in the telecommunications area who all they do is innovate. Their whole product, they don't have a product other than the innovation. Or in universities that we've talked to, you know, research hospitals, independent inventors. Our country was founded on independent inventors. At the time we started the patent system, 80% of inventors didn't even have a high school education. They knew that it was going to be about licensing. They knew that these people were going to invent and then license to others who had the channels of distribution and access to markets and manufacturing. And then the investors. I mean, the investors need to have some protection. So it seems to me that there has to be a way, and it would be much more persuasive for our side to say, look, these are the people who have, quote unquote, skin in the game. You know, they're inventing. They're in the business of inventing. Maybe they're not operating in the same way as they're patenting, and then they're the ones getting the manufacturing and distributing and selling the way, like, you know, like a small competitor versus small competitor might be. But there's all these people that are in this ecosystem who are not the people who were in, like, in the BlackBerry situation. Well, let's just buy up a patent and hold up on a major American corporation that everybody relies on. Okay, there needs to be a way, I think, to distinguish between that and say, no, the person who invested the PMI, in a mortgage, the PMI money always gets paid first, right? Because without them, people can't buy the homes. They can't build the homes, right? Why can't we do something like that?
Well, it's frustrating, especially as being more involved in the patent end of things. You know, we're all IP lawyers, but an awful lot of what you and I do anyway relates to patents. But we don't seem to object if someone swoops in and buys trademarks out of bankruptcy and then sets about stopping others. We don't seem to care if somebody swoops in and buys copyrights. Does anybody care that, Michael Jackson's estate owns all the Beatles music or something crazy like that?
Well, Paul McCartney cares.
Yeah, well,
but right, no, you're right.
Or that Taylor Swift, the reason for her success is she owns it herself.
Right.
You see, as opposed to music plays, or that Harper Lee, she wrote one good book. And that is essentially, and we have other authors, they did it once and that was it. That set the pace for them for their entire lifetime. But as an inventor, we can't seem to recognize that as being a similar contribution. And for the life of me, I can't figure out why.
So I agree with you, and I'm not playing devil's advocate here. And this is why I think people on both sides of almost every issue disagree with me. Because we've gotten to this space where there's this purist. If you're not purely 100% on my side, then you're the enemy. And it seems not just in our space; it seems to permeate politics, it permeates religion, it permeates everything. And I don't know how to break out of that cycle. But so I don't disagree with anything that you've said. But what I want to do is the lawyer who's trying to persuade others. And then also because I do think I have a vision of the way that it ought to be, and it would be better that way. We got to get there, and you can't always get there all at once. And, this was why Reagan and Tip O'Neill were able to do business. They
half a loaf
of bread, right? Why can't we get to the point where it's like, okay, let's solve this for the biotech innovators, the pharmaceutical innovators, the telecommunication innovators that only innovate. That's their product. For the universities, who by definition are just innovating. For the independent inventors, who just have to be just innovating. Solve it for them, and then also maybe include the investors in all of that, right? So if one of these entities that gets stood up goes belly up and bankrupt, then the person or people or entities who put in the money, they're legitimate patent owners. And because I think if we could do that, then what we've done is we've solved 90 to 95% of the issue. And then the fact that we didn't get 100% all with one signing of a bill or something, well, we can always go back and try for more later if we step back and that wasn't enough. But I just think from a persuasive standpoint, we're not doing our side any justice.
Well, I think what would help is if the patent office issued valid patents, because that's the other side of the coin that people say, but, if so many of these patents can be challenged and end up not being valid at the end of the day, then why do we vest such authority in a patent to stop others when there's a great likelihood, 4 out of 5, that it may not be valid? And that, $500,000 or $1 million is spent trying to undo what the patent office has put in place. And so my thinking is, like you say, there's many ways to make this happen and many things to have to happen at almost the same time. Number one, get the patent office working again. The backlog is growing. And you need to turn out patents. People have paid for their examination. They need it in a commercially relevant time frame. But that examination has to be quite good. We need to get AI, other resources available to the examining corps such that when you have a U.S. patent in your hand, the likelihood that it's invalid is at least less than 50-50. At least.
Right.
Less than 50-50. Because going forward, I think that would generate a lot of confidence in the system. Mm-hmm. Then I think the rest of it begins to sort itself out. You restore injunctive relief for the most part, not in every case. You make the PTAB much more like a district court in how it operates. If it's going to be a replacement for a district court, make it like a district court. And then sort out subject matter eligibility so that the efforts of the software folks and the diagnosticians out there who have been just put out to sea since Alice are invited back as a part of our economy, and they too can get patents again. I mean, all of these things are like logs on a fire.
Right.
Not one of them will help, but all of them might begin to make a smoldering something that is the renaissance of our patent system.
Yeah. I'm in favor of having the patents that issue be better. The problem with that is a lot of times there will be late arriving prior art or things the examiner didn't see or nobody found or didn't appreciate, what this claim really is going to be used for. When you look at these things in one eye with one set of eyes and you're like, oh, okay, I think that, that's fine. Then you see how it winds up being used or developed in industry or used for enforced. And it's like, oh, well, if that's what you think these words mean, then these other pieces of prior art are relevant. And there's always going to be that tension. And so But for me, the thing that really just has to be solved for is the patent can't be challenged for every last minute it exists.
That's the other thing. You've always, and for I think at least a decade and a half, advocated for the idea of quiet title. And you have it on the trademark side where you can't go back and try to get rid of a trademark after a certain time. Certain things are presumed in your favor, and likewise in copyrights, registration gives you certain presumptions in your favor. I think on the patent side as well, after 5 years, let's say, and that's an arbitrary number, but let's say after 5 years, for the balance of your whatever your 20 years is left, you ought to have quiet title to that.
Right.
That if people thought your patent was such a concern, they should have challenged it earlier on. And I'm just throwing an idea out there.
No, I totally agree with that. And then people say, oh, well, the Supreme Court says, everybody that has a right to challenge, right? Well, that can be changed. And you don't need a constitutional amendment to change that.
But we have this arbitrary time limitation for PGR, post-grant review, 9 months.
Right.
Get your act together. And if 9 months comes and goes, the things that you can bring to bear to challenge validity go way down. And now it's just patents and printed publications. So we already have something like that in place. Why not go out 5 years and say, you're done. Your only venue now is a district court, and you have to face presumed validity and so forth. You got to build toward a bulwark where after a time certain, you're done.
I totally, and we all
something like that.
As you mentioned, we have this on the trademark side, right?
Yeah,
where and it's not that every challenge. I mean, if you can prove that there was fraud, you can challenge for fraud. If the trademark became generic, you can challenge for that. But for everything else, you get 5 years, is presuming the owner seeks incontestable status. We need to have something like that on the patent side, and we do it every day in every town in the country with respect to taxes and real estate. It's like we're gonna seize this property. The government's gonna seize it for failure to pay taxes. Notice goes out. If this matters to you, show up. If it doesn't matter to you, no big deal. People are in bankruptcy court in every federal district court in the country every day, and the same thing. Notice goes out. If you have a claim, let us know, because once this is discharged, it's over. As long as the debtor actually told us everything that they owed. We have ways, and we also have ways that if we don't know who. Well, post notice in the paper. I mean, that's been around for hundreds of years.
Yeah, constructive notice. Remember, Gene, there's that famous legal phrase, constructive. We know, both of us know it didn't happen.
Right.
But we presume it did.
Right.
Because it's constructive.
Right. That's funny. And I think that Dennis Crouch was the one who put that in just like perfect a few years ago when he wrote it. He said the word constructive means it never happened.
It didn't happen.
Yeah. So, okay. So I think we agree on a lot of that, and I think a lot of these things would make the system certainly make it better.
Well, what it does is it invites engagement, and like you say, the characterizing features of the American system have always been low cost, low threshold of knowledge or scholarliness, because we want everybody to participate, because Edison, didn't have much formal education, and you can't exist presently without taking advantage of some of the things he did by now more than 100 years ago.
Right.
They're foundational.
Right.
And so our system has always been simple, approachable, with great benefits flowing to the public. Let's get back to that.
Right.
Because I want the Edisons of the world to realize there's a chance for them.
Yeah. No, and that's Lincoln had it right. You want to tickle that gene that we possess that gives you the ability to grab hold of what you've contributed.
Yeah, and
the fire.
And the Supreme Court, I don't like all the extra words they used in KSR, but fundamentally they said, look, we recognize that everybody has sort of a base level of creativeness in them. We should give patents out for what goes beyond that, because we as a society want to embrace what goes beyond. And that was Jefferson's sentiment when he was our first patent examiner. He wanted something that was more than just useful. It had to be sufficiently useful. And this, came forward in obviousness and all that. But the Supreme Court, in their own muddling way, said, look, we recognize everybody has a base level of creativity. We want what's beyond that.
But it's because they didn't really know what they were talking about, and because things had gotten so mucked up, and they needed to say something, or they felt like they needed to say something. We have these now 7 rationales, when in fact they're 2. And they didn't even really notice that they had created 2. They said, okay, TSM, teaching, suggestion, motivation, still, if it's TSM,
sort of
no
a
patent for you.
Way to prove obviousness. TSM, right.
Number 2 is if it's reasonably predictable, because all the other rationales, everything else they said, it boils down to predictability.
Right.
And so we have this unnecessarily complicated regime for obviousness, when in fact, it really, I think, when you step back and you see over because this is in 2007, we're approaching 20 years. We're about 18 years since that decision. You look backwards, and I think what they were probably trying to say is the Supreme Court in Hotchkiss actually got it right in the 1850s.
We want something beyond the mere mechanics.
Yes.
Yeah.
And and this becomes a problem not in just our area of law. I think all areas of law, where the more specific it gets, and there's this canons of construction, right? If it's super specific and doesn't include something, then that's not included. Once upon, and this is my gripe with patents too, once upon a time, and it's not that long ago, 50 years ago, 60 years ago, you read these patents, and there are 3-4 pages for extremely complicated inventions, and everybody knows what's covered. And nowadays, there can be 100, 150 pages or more. You submit CD-ROMs with data, so much information, hundreds of pages of drawings, and nobody really knows what's covered. It's like, what the hell happened? And you go 100 years ago, and patents were a page. 1 page of text and 1 page of drawings. And the drawings were really good, and they were artistic, and you could understand what the invention was.
Well, and there may be something to that if you can't describe your invention in 20 pages, then break it up. Because maybe that's where we should go. Bite-sized patents that even a judge can understand. And I don't mean that in any pejorative sense, but unless a judge can understand it, it's very hard for them to enforce it.
If the judge can't understand it, what hope does the jury have?
Well, right. And so, because the judge is determining what this actually covers and doesn't, and you read some of these claim determination things, and it's like no one in the room speaks English, or at least hasn't.
Right.
And then suddenly a dictionary is unhelpful to these people.
Yeah, and I think the patent office would love to have more bite-sized pieces.
It's absurd. And so I think that would certainly be helpful. And when you have necessarily something that goes beyond some threshold, then a lot more money is charged so that the patent office can get a handle on it.
Yeah.
Because it seems silly that you pay the same amount for a 10-page specification as you do. I know there are size fees, but they don't go to examination. That doesn't give the examiner any more time because it's longer. It's just the patent office, because their electronic chit is slightly larger, they collect the money.
Right.
And so that's silly. So we need to get our patent system working again. Direct the collected resources to getting valid patents out the door.
Okay.
Let's start there.
So I want to go backwards, because I said I had 2 reasons, and we kind of went off on the one. The other reason where I think this went awry is, and it maybe picks up on this conversation we're having right here now with innovation and invention and stuff. We don't have a universally accepted definition of innovation. And that to me is striking, and because if you go up on Capitol Hill or go anywhere, you could actually do like a Jay Leno Man on the Street kind of thing, or now other people do that too. Late night hosts have always done that. The man on the street, who do you know who the vice president is? Those kinds of questions.
We have one.
You could go, and I suspect everywhere in the country, but certainly in D.C. on Capitol Hill, and say, are you pro-innovation or are you anti-innovation? And to a person, you're going to get everybody say, pro-innovation. Okay, so now,
it's part of our culture.
Yeah.
It really
so now,
is.
what does that mean to you? Okay, now what to a lot of the big companies who, for lack of a better way to describe it, in my estimation, don't want strong patents because they're doing so much and they do get in their way. They just want to do what they want to do and don't care about if they're infringing. And there's some companies, some of the big tech companies have very publicly taken that position. Do to their people, do what you want to do. Don't worry about it.
In fact, don't look at patents because that may be held against us.
Yeah,
that you
don't
actually informed yourself.
And some of them have actually taken positions and policies, and Facebook one very forcefully and publicly over the years is don't be afraid to copy. So these are the positions that they take, because to them, I think innovation is getting something out into the public, into the consumer. And the fact that, well, big tech company A has never had this. So like I have a pair of glasses right here. Like if you put a camera on this, like Google Glass or whatever thing you have, right? Like a GoPro glasses, easy to wear, whatever, right? Okay, well, the first time somebody does that, it's an invention. Okay, and then the next time somebody does that, it can't be an invention. And I think we all understand that, right? The same exact thing. But if company A comes out with this and they've never done it, that's innovative. Okay, company B comes out and they've never done it and they do the same exact thing, that's innovative. They're increasing innovation. Mm-hmm. No, you're not. You're just doing the same thing that somebody else has already done. And then you have the difference between, well, I'm the inventor, I have the patent, I haven't done it. Well, you're getting in the way of innovation because I could do it, you could never do it. And it's like, okay, so we have all these different ideas to different people in the ecosystem of what it means to be innovative. And that word then gets transposed over top of the word invention, which is the patent word. And then it's like a thread gets pulled and you wind up with a jacket with no arms.
Yeah, I think we have to all understand that invention is an aspect of being innovative if what you've come up with meets the thresholds to get a patent. Because, for example, Henry Ford, what was his innovation in the automobile industry? Vertical integration. So cows and iron ore came off the boat, automobiles left. He controlled everything, literally from the raw materials, the mines, making the steel, turning the cows into leather and so forth. He controlled all of it. Well, up until that moment, no one had vertically integrated an industry of that scope. And it was astonishing. It was very innovative. But did anything merit a patent? No.
Right.
What he had was financing and vision. And for heaven's sakes, the Rouge plant was built in a swamp. I mean, because it had access to water.
Right. Well, and the assembly line would not today be anything that would be particularly innovative.
Well, I mean, and
the reason I say that is because Samuel Colt, very famously, is really the first person that, certainly with guns, and I think with anything, figured out that we can't make these one-off. They can't be. We need to make all the pieces and parts together so that you can have fully interchangeable pieces and parts with respect to products. And he did it with the 6-shooter, and that became the gun that won the West. Yeah. And then in one of my podcasts recently, I had Arthur Damerich, who who's a historian. We talked about this whole thing and how that then becomes the precursor to the assembly line, right? Well, if Samuel Colt figures out that this is what we need to do, this is how I need to do it, and then somebody says, oh, well, we'll just put it on a conveyor belt, that's a business method.
Well, but
and you couldn't get a patent on that.
Henry Ford, didn't invent the assembly line. He applied it to something as complex as an automobile, and truly figured it out. But you may or may not have heard Cadillac's standard of the world, and so. Mm-hmm. The reason they got that moniker is they're the first ones for something as complex as an automobile made every part to be interchangeable with any other car with that same part. And so, like you say, the 6-shooter, they did it for an automobile. And they took 3 Cadillacs to London, part of some World's Fair. They disassembled all of them, randomly redistributed the parts, and remade the cars. And they all worked. Mm-hmm. This was a revelation. And so forever after, Cadillac is standard of the world. No one knows where that comes from.
Right.
It came from exactly that.
Yeah.
So does that warrant a patent? No. That is an innovation, though.
It is an innovation, but does it work? I mean, certainly today the answer is no. You couldn't get a patent on that, right? And I think we need to, and we will have to fundamentally reconsider these things in a world with artificial intelligence at some point in time, because if we do want this level of innovation, we've got to give rights. Otherwise, investors can't possibly invest.
Well, that's the key. Is that without the preservation of the value of what your efforts have created, you can't have more. It is perennially going to be a hobby. Well, it's something I'm working on in my barn. Oh, why? Because I can't live on it. And we have many inventors right now saying the inventors have to get paid, and that's true, because without that, they have no capacity to keep innovating, keep inventing. They just can't. And so you need to have a mechanism they can realize the benefits of what they've done. Otherwise, we don't get more of it. And as a society, I think we can go right back to Jefferson and Madison, the fundamental debate. Why do we want a patent system? To create the future that we all want to embrace. And so we need to foster its best version now using AI, whatever the tools are to make it the best we can right now. And you need resources, you need focus, and you need resolve. We've been chasing adjustments to eligibility now since Alice, which I think was 2014, right? Mm-hmm. So we're now more than a decade down the road, where we have summarily taken essentially computer-implemented methods and things and said no patent for you. And the same for diagnostics. We are all the poorer for it as a society. And we're a decade in, and our politicians can't solve it for us. They just can't. There's too much money on each side of it. And so I'm not going to say that's a good or a bad thing. That's just the way it is.
It's just the way it is. And the thing, too, is and I think, as you know, I think about these issues an awful lot.
We both do,
and
yeah.
I think...
We're very exciting people, by the way.
But
just ask us.
I think what happens in one of the reasons the Supreme Court hasn't gotten involved, I think, is I think they thought what they were doing was correct and was going to end all this, and they were going to sort it out, and that's what they had been told, and they had been told this wasn't that hard.
Sure,
it just needs
a rational reading of Alice is there's nothing to see here. But then when that gets applied and extrapolated by silver-tongued devils out there working as attorneys, pretty soon nothing's patentable.
Right. And I don't begrudge the attorneys. I think the judges should have had their eyes a bit wider open and been involved in a way that they in previous years they, at least the Federal Circuit, would have controlled this. But I think the problem becomes is if you try and solve for 100%, then it becomes like, well, what do I do? How do I do that? Like we're in this studio right now. Just before we started, we were talking about like, well, the cameras. How many cameras can you have before the one camera starts getting in the way of the other camera? And then we're doing this at IPWatchdog, and we do live events here, and we have the studio and audience there and everything like this. And, it almost becomes at some point overwhelming if you don't realize, okay, well, that person's sitting right there. Unfortunately, if that's where they want to sit, fine. But there will be a camera that is going to partially obscure the speaker in this seat, right?
They might have to tip one way or the other.
And because if you don't realize I can't get the right lighting and solve for 100% of it, I can't do it. I can get the 98% solution, but if I have to get the 100% solution, then that's the only way to do it. Sorry, I'm just going to give up. Okay, so now extrapolate that into the patent eligibility for a minute. For example, well, if we have the rules here this way, well, that would allow X, Y, and Z. Okay, yeah, but those are the only three things that you'd have to tolerate. Well, we can't tolerate those. You got to go back to the drawing board. Well, and no matter what you have is a situation.
The problem there is that we're holding out for what we perceive as perfection. The problem is even when a statute is written precisely in the way that you had hoped, and we watched this with AIA, in the hope that or otherwise available to the public would be interpreted to qualify the language which preceded it, such that secret sales and secret uses would not be invalidating secret sales or uses. This was exactly the language that folks wanted because they understood what it meant, so they thought. And then it gets run through the sieve of the CAFC and the Supreme Court, and it means exactly the opposite. And so those who are holding out for statutory perfection, I think, are misguided in the sense that the courts may not see your perfection, and it may not become your perfection, because those folks in that realm who hope to rule out secret sales and secret uses were inconsolable after Helsin.
Well, they were, but the thing is
and
okay.
I told them it wouldn't happen, but
we both did, and we were marginalized. We were like, you don't know what you're talking about. I was like, no, I don't think you know what you're talking about.
But the point being not that, we're savants or we're seers or any of that, although we are, but that if you hold out for certain language, don't feel that that's the end of the argument, because it then has to pass through the sieve of the CAFC and Supreme Court, and it may or may well not go the way you hope. So let's get going, and then correct our path as we go.
Although what I would encourage people to do, and I'm going to upset a lot of friends when I
ask you and me
this.
first.
Well, if they listen to us,
listen to us.
Number one, but number two, the people who disagreed with us on the Helsin, on the secret sale issue, for example, were people in the room negotiating based on behalf of clients or based on behalf of industry organizations.
They literally wrote the checks to make sure it went a certain way. And
but,
I'm not going to say that was good or bad, but they got the seat at the table to make sure these things went the way
and they were
hoped.
told. They were told. But nowhere did that actually ever get put in writing. And then you wind up being, I think, a little bit too smart for yourselves in some ways, right? Because we've been told this. This is how. Okay, yeah, you've been told that, but if they won't put it in writing, why won't they put what they told you in writing? And then it becomes just a simple statutory construction matter to say, look, sales, secret, otherwise, have. It doesn't matter. It's a sale is a sale is a sale. That's been the law since George Washington was signing patents, right? Or whenever it first got into the Patent Act, right? And so to change something that's that well established,
they should have written it down somewhere.
They should have wrote it down somewhere, or even in the legislative history, the best that they had was like a footnote to one thing, and it's like, okay, well, the Supreme Court. I just followed their own rules. Is if you're going to change something that is that well established, there needs to be something somewhere. It can't be a backroom handshake deal that this is what's intended. And I think that that's sometimes part of the problem.
Well, it's the way our system works. If you're going to have a real course correction like that, something as fundamental, it needs to be heralded by more than just a comma.
Right.
Which is how that was done. Oh, so the comma means it qualifies the preceding statement. No, it means it's in addition to.
Right. Yeah, and these legislative histories, they could say whatever they want. There's no reason why somebody somewhere couldn't have added something that said this, and at least it would have given some argument. I mean, so that's the one thing that I do think that we need to be mindful of is if you're going to try and change the system, you gotta be very careful, and you have to be very explicit.
Well, and so don't, go with half a loaf and then course correct, and because the system can do that. Back in the 1999 Act, and they're always titled so wrongly. That was the American Inventors Protection Act. It had nothing to do with protecting American inventors. In any case, they made an adjustment to 102E simply to accommodate the newly published application. They made such a mess of it that it had to be adjusted within a couple of years, and it was in 2002 they fixed what had been messed up. And so don't feel like, gee, if we don't get it right now, we'll never have a chance to revisit. No, we can.
Yeah.
And we can. So don't. And
we should have done that with the PTAB well before now.
Right. Right. You know, a lot of things about the PTAB. If it's going to be a substitute for a district court, then make it mimic a district court in how it operates, but take advantage of the technical expertise that is allegedly on hand at the patent office to help you. You know, and I say allegedly in that the PTAB seems to be isolated from those with the real technical expertise, which is all the examiners who examine in this all the time.
Right, right.
You'd like them to at least have a look.
Yeah. Which would be an improvement to the whole system, I would think.
Yeah.
So we've been going for a while, but before we end, I teased it earlier in the conversation that you, once upon a time, when you were an examiner,
Indeed,
you used a certain very old book, the oldest book.
That's right.
As a reference. Can you and you tell this story in our patent bar review course, but probably most people have heard it before, but it never gets old.
It's a fun story, and it's simply this. This was I was an examiner. I was encouraged by a fellow examiner. I can't say that this was completely conjured on my own. I've been at the patent office maybe 6 or 8 months, and I was still examining cases. And in the civil engineering space, I transitioned to automatic transmissions, clutches, and all that later on while I was doing speech writing. And so I went to an examiner to talk about, well, where can I find this brick material with fiber in it? And we're sitting around talking about, because when you went to get a search, it was class, subclass, you might find it here, might find it there. And he goes, but of course, you'll find it here as well. And he happened to have a Bible on his shelf. And he pulls it off the shelf, and we flip to Genesis. Well, actually, it's Exodus. It's the beginning. It's the predicate for the Jews leaving Egypt, that the straw that was otherwise incorporated into the bricks was going to be withheld, and they'd have to go get their own straw, the stubble and stuff like that. And he goes, well, there's a story right there about fiber and bricks, so we ought to be able to find it. And I go, what do you mean, find it? You found it. I'm going to use that. Yeah. And so I used Exodus as the basis of a rejection of this application, because the basic claim was a brick made of brick material, including, fiber. And so there it was, there in the Bible. Now, this fiber happened to be made of a certain polymer. It happened to have a certain caliber. It was a certain length. It happened to have a certain temperature at which it would turn into ash, which in the brick would create these little passageways, all that. But that wasn't in the broad claim.
Right.
And so the broad claim was rejected on the Bible. And the reason I tell the story, of course, is because if the first book ever published by Gutenberg is a good reference, then any book ever published is a good reference. And so there's a point to the story.
No, I know it is. There is a point, and it's one of those things that once you hear, you can't unhear, and you'll always remember. But what was the reaction from the attorney?
Well, the reaction was they amended their claims, and they obviously got a patent because this was a real innovation. It was bricks for lining high-temperature furnaces and all that sort of stuff. But, the point is, you go in there with unrealistically broad claims, and you got an examiner who's a real jerk. You're going to get a rejection as silly as your broad claim.
Right. I mean, if you're being ridiculous, don't be surprised when the examiner is going to be, examiner.
Yeah.
But examiner is going to be equally ridiculous.
But it is a funny story. But I think people in the patent bar review, that's the one of the several things they always ask if they see me. Did you really do that? Yes, I really did it.
Yeah, but and I think just to put a pin in that, and I think that story is incredibly relevant today, though, because the one thing that we do know about the PTAB, if the patent that you get winds up being valuable to somebody more than just the company who got it, an industry valuable, the odds that it's going to be challenged at the PTAB are really pretty high. And when it gets challenged at the PTAB, you ought not to be getting claims for people where you're walking around the office high-fiving and saying, oh, see what I got the examiner to agree to, because those claims aren't worth anything anymore. And they don't scare anybody anymore at all. And I think and that's why, consequently, as you know, we hear from people, chief IP officers, chief patent counsel at some of the largest companies in the world, they want narrow claims.
Yeah, because those are valid. And if people copy what it is they're doing commercially, they want to be able to stop it. Right. And they don't want to have this interim pass through the patent office, which has no end in sight, with these multiple and serial PTAB challenges with IPRs and so forth. If you have good claims, cover what you're doing, and they in fact distinguish from the prior art, you're good to go.
Yeah.
And
that would be a good change too, is if more people had that insight.
Yeah. But they don't. They're still high-fiving each other over, well, I put one over on that examiner. Well, you didn't do your client any favors.
You may have won the battle, but you're going to lose the war.
You're going to lose the war, and it's going to be a very costly war in the end.
Yeah.
So.
All right. Well, great. Hey, this was a great conversation. Thanks. This is how, and when we used to travel the country teaching patent bar, this used to be our evening over drinks and dinner conversation.
People can't fathom that there's this much to talk about in patents, and I can't fathom that there isn't.
Yeah, no, I know. There's a lot.
And we barely touched the surface.
No, we did. We didn't talk about all. We talked about some of your great historical anecdotes. We'll have you come back and we'll talk about more.
Happy to come back.
Thanks a lot, John.
All right. Bye for now.